Good morning. The first case today is State v. Balmert. Each party will have 15 minutes to present their argument. The appellant will have up to 5 minutes for rebuttal. How long would you like to have for rebuttal?
Yes, 5 minutes, please.
I'll be keeping track up here, so I'll try to let you know when you're about a minute left in your time.
Okay, thank you.
Initially. The arguments are being recorded. When you present your argument, number one, please introduce yourself. You come up to the podium. Please stay behind the podium and please keep your voice up so we can hear you well on the recording. If you have to refer to any children or victims or anyone, please make sure you use initials in this matter or some other way to designate who that individual is. We read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, my name is Stephen Canada. I represent the appellant Edward Balmert. And in this case, Mr. Balmert was charged with 2 counts of OBI. One was an OBI based on actual impairment, the other was OBI based on the presence of prohibited levels of marijuana metabolite in the system. He was acquitted of the actual impairment OBI, but was convicted of the OBI based on the prohibited levels of impairment, the prohibited levels of marijuana metabolite in the system. Now, this ultimately is about a collision that he had with a state trooper who was directing traffic at Route 2 and I believe it was Middle Ridge. And so the question before this court is whether the prohibited levels of marijuana metabolite in Mr. Balmert's system was a proximate cause of the collision, because the aggravated vehicular assault statute based on OBI requires proximate cause. It is not an automatic element, just because OBI is proven. It is a separate element that has to be proven in addition to the OBI. And I think the trial court was mistaken by treating it like it was automatic, because when it comes to metabolites, and unfortunately, because the issue wasn't raised in the trial court, I can't raise the constitutionality and the lack of rational basis for the statute. But metabolites are the substances left over in your body after your body has broken down and metabolized the psychoactive ingredient. So in this case, marijuana, after the psychoactive ingredient is THC that's been broken down and metabolized by the body, and what's left over is metabolite. And that metabolite can stay in your system for some time afterwards. And so, that's certainly useful, let's say, for people on probation who are not allowed to ingest marijuana, and they do a urine test or whatever, and then those metabolites show up, and that would show that they violated their probation. But in this case, metabolites does not equal impairment. Only the THC can impair you. The leftover metabolites in your system from when you consume marijuana at some point in the not so distant past, there's no evidence of impairment, and the trial court recognized that. That's why the judge acquitted Mr. Balmert of the actual impairment OBI, but there's a statute on the books that says if your level of metabolites is above a certain level, then it's OBI. If you drive with a certain level of metabolites in your system, it's OBI. And I don't think that's well based in science, but it is what it is. That issue wasn't challenged. But now the question is before this court is, was the prohibited level of metabolites the proximate cause of the collision? And the answer is no. I mean, the state did not prove that point whatsoever, and that's where I'm arguing insufficient evidence. Certainly Mr. Balmert was negligent, and it certainly warrants him to be sued civilly, which is what has happened. But there's other factors in this case, like he didn't wear his corrective lenses that day. He had other medical issues that affect his ability, affect his motor skills and his driving. I mean, he gave up his CDL license a while back. So, when it comes to proximate cause that the state has to prove, they have to meet the prohibited concentration of marijuana metabolite has to be to the exclusion of all other factors. It has to be a direct correlation. It's got to be a substantial factor in the crash. And there is at least case law from the 6th District that says that proximate cause in this case, it is the same as the proximate cause that is applied into tort cases in civil law. So, in your run-of-the-mill traffic crash and in tort cases, the proximate cause standard is the same. And the state presented no evidence that the fact that Mr. Balmert's, marijuana metabolite levels were above the statutory amount, which was just picked by the legislature back in 2005, again, not based in science, but that's what the legislature picked, that the mere fact of his metabolite levels being above that statutory limit, the state presented no evidence as to how that caused him to cut his term short and hit the trooper, and sideswipe the trooper and knock him to the ground. And so, otherwise, absent of that, all the other facts and evidence in this case shows this was a simple act of negligence on Mr. Balmert's part.
Counsel, what about the testimony of the drug specialist? Didn't he provide evidence of impairment?
Well, not to the point where that convinced the trial court. The trial court acquitted Mr. Balmert of actual impairment. But there was an he was charged with OBI based on actual impairment, and the trial court acquitted him of that because as I believe it was Sergeant Small, or Lieutenant Small from Medina County came up to do the DRE analysis, that there was just, there were too many other factors that would account for, that just don't add up to impairment, and Small admitted that on the stand, and it just, that analysis was ultimately insufficient to determine whether he was actually impaired at that time.
Counsel, how is that different than the case law where we have inconsistent jury verdicts, but we don't delve into the reasoning behind it? I mean, is the acquittal on the impairment charge the end of the story? Is it, because if a jury came back with those, we would say, well, we can't speculate as to why the jury acquitted on impairment.
I think ultimately, as a matter of law, that the acquittal of the impairment charge, you have to presume that he was not impaired, because ultimately the state's burden to prove that he was impaired. And so therefore, that you can't use impairment as a basis of proximate cause for the crash. And so the only basis that can be used as a proximate cause when it comes to aggravated vehicular assault, as charged in the indictment, is the prohibited levels of marijuana metabolite. I understand your point about, juries can come back with an inconsistent verdict, and that's something that the attorneys have to take up in post-verdict litigation to say, hey, we have an inconsistent verdict, the court should rectify that, especially if a jury were to acquit of actual impairment, but then still convict the defendant of an aggravated vehicular assault or homicide based on actual impairment. I mean, certainly there would be an inconsistency that the trial court would have to address afterwards. But in this case, this was a bench trial, so there was no jury, and I think when you look at the judge's analysis after he found Mr. Balmer guilty of the marijuana metabolite, OBI, and then also the aggravated vehicular assault, he basically treated it as if he didn't, it was like an automatic, as a proximate cause automatic. Because he said it, I must find you guilty. He didn't engage in any analysis of, okay, we know he had a prohibited level of metabolite in the system, now we got to look at, did that cause the collision here? Was that a substantial factor in the collision? There was no such analysis made. He just said, oh, I got to convict you of this too. And I think, that's where the judge was mistaken. He treated it as if it was an automatic, and proximate cause is not automatic. That's an additional element that the state has to prove. And so, because you could, somebody could be driving impaired, and yet, get into a collision that has a totally different cause. Where they could be going through a green light, and then somebody who's unimpaired going through a red light, and cause a collision. So those kinds of situations are certainly possible. That's why there's a proximate cause element to this, because a person driving impaired who gets into a crash, the crash may be because of something else, not because they were impaired. And so that's why it's in the statute. So the state of Ohio did not prove that the prohibited level of marijuana metabolite was a substantial factor or a direct cause or proximate cause of the collision with the state trooper in this case. And I think when you look at all the other factors, and this goes to a manifest weight challenge as well, when you look at all the other factors, this is just a simple case of that, Mr. Balmer just was negligent. He wasn't wearing his glasses that day. He admitted in his testimony he wasn't paying attention. He looked to the right, didn't quite look to the left like he was supposed to. I mean, unimpaired drivers do that all the time.
And I'll knock you down to a minute of your initial time.
And so this is a classic case of negligence which, he's been sued civilly for, in which that proceeding goes on its own accord. And this is just a simple case of him being overcharged. So I'll reserve the remainder of my time.
Thank you. Thank you. Have your full time for rebuttal.
Good morning, Mark Koza on behalf of the Lorain County Prosecutor's Office in the state of Ohio. Appellate counsel is correct that this matter does come down to the proximate cause, and if we look specifically at the case law from the 6th District that we both cited, specifically Moore, Philcock, there is proximate cause, as they defined it, is the civil term of the defendant's conduct is a substantial factor in the cause of the accident here. And if we look at it, the issue with Moore was that the state just basically said, your BAC, your OBI, that was a marijuana metal, I apologize, you're per se level, therefore you're guilty of this. And the 6th District overturned from that. But that wasn't the case here. There was more than enough evidence that went to show the factors of those prohibitive levels in Mr. Balmert's blood, the THC specifically being 5 times the legal limit, but we had 2 DRE officers testifying here. And I think the first one, Sergeant Frankway, initially looked at it, and he did the initial factors, and he said you have to look at the metabolite and the factors of impairment. And he, as a DRE designated, he took him through the A-RIDE system, the first 2 steps, and he found that he was unfit to drive a motor vehicle. In that situation, because he knew the victim's CG, he then decided to step back and say, we need a third party in here so that we can be more objective, because at the time, the troopers Coachella and Karski, they were very upset. This was their co-worker, so they needed to take a step back. And then they took Mr. Balmert to the station, and Lieutenant Schmall took him through even further steps, all the typical field sobriety tests and additional testing. And if you look at the record on 180, he determined that Mr. Balmert was under the influence of cannabis and was unable to operate a vehicle safely. Both officers testified to how cannabis slows one's reaction time and impacts one's ability to drive properly. And we have here Mr. Balmert testifying. He wasn't paying attention. His wife had to tell him, hey, they're waving you through the intersection, and then he doesn't even see them. You have additionally 2 other lay witnesses who were there and said, yeah, you took the turn too tight. You could clearly see her there. So I believe the state has more than enough presented evidence with regards to that first assignment of error, the approximate cause that his metabolite impacted his driving and was the proximate cause of Trooper CG's injuries here. Looking towards the appellant's assignment of error 2 with regards to manifest weight, the first issue, I don't think there was nothing in this case that no one rebutted any of the testimony of these officers or anything, so no one was impeached, so none of their credibility, so I don't believe he reached it there. He hangs his hat very much on what the trial judge specifically said. The trial judge is not required to put his findings of facts or his reasons on the record, but even if we look at his quote, he said that while violating 451119, the per se statute, because the lab result shows you did cause serious harm while operating a motor vehicle while having that in your level. So the trial court was recognizing the THC metabolite and that causing the symptoms, but the court had heard all this additional information.
So what of the comment that the court said, since I found you guilty of the per se metabolite violation, I must also find you guilty
Well,
of the vehicular?
Sorry to interrupt you. I would say that if you look at the second part, it says you did cause serious physical harm while operating the vehicle.
But that's a different element, isn't it?
I would say that you did cause serious physical harm. The cause goes to the proximate cause, so the metabolite plus causing it is how we get to the ag vehicular assault.
Isn't the isn't the question whether the impairment is the cause, not whether or not he actually caused serious physical harm by striking someone with a motor vehicle?
I would agree with you, but I'd also say that there was more than enough evidence, Your Honor, that his impairment and he being impaired caused the accident.
Can I ask you a question about the out-of-county expert testimony?
Yes.
Was that individual qualified as an expert at the trial level?
I believe the beginning of his testimony was quite extensive on his background. He had 300-plus training. He went to out of state in Michigan and did significant training on this. I don't think there was anything specifically said on the record. I do find you to be an expert, but based on his training, his experience, all those factors, I think he would have been qualified as an expert in this case.
And he opined, we will obviously read the record, but we haven't had an opportunity to do so before today, or at least I haven't. That individual officer opined that, in his opinion, at the time of the accident, Mr. Balmert was impaired due to the levels of something in his system.
The direct quote from the record, Your Honor, is that he was under the influence of cannabis and was unable to operate a vehicle safely.
Thank you.
That was his exact quote. Moving forward to assignment error 3, the state does concede that the trial court did err, that ag vehicular assault is not an offense of violence. We would say that, as we said in our brief, very briefly, that is a limited issue, that if the court is to uphold both other assignment of errors, that if they were to reverse on this one, he would just be resentenced for the limited purposes on post-release control. Thank you for your time.
Thank you, Your Honors. As to Lieutenant Schmoll's testimony, he admitted in cross-examination that he had no special training in eye examination or ophthalmology. He's not a doctor, and he also acknowledged that Mr. Balmert's high blood pressure and calmness in of themselves are not indicative of drug use. So ultimately, Lieutenant Schmoll, despite whatever training he has, he's not a medical professional he's not a doctor who can really look at take an entire holistic view of the body and all the person's, conditions and medical issues and whatnot, and be able to determine, why he's acting a certain way. I mean, some people are more calm in their nature, and other people are more high strung. So, and then also in the testimony that Mr. Balmert, he takes medication to deal with his rheumatoid arthritis, which that has side effects on him as well. So it's just, you can't just, look at things in isolation and be like, oh, there it is, he must be impaired. And I also implore the court to, do its own research as far as studies that are out there about the accuracy of DRE analysis. And I don't know if that really necessarily came up very much in the trial itself, but I think this court can, at least cite studies that have been done. I mean, I'm talking true scientific, double-blind studies where, control studies where they know someone's impaired and they have a DRE person do an analysis, or they know someone's not impaired, but the person does the analysis, and how often are they accurate?
Well, counsel, is that not an invisibility issue as opposed to a weight issue?
I mean, at the end of the day, Mr. Balmer was acquitted of the actual impairment of the eye, so I didn't put as much emphasis on that part of the testimony simply because he was acquitted of the actual impairment. So the trial court was not convinced of the state's presentation of evidence regarding the DRE and other evidence to convince the court that Mr. Balmer was actually impaired. So the trial court was not convinced, so the court acquitted him of that. However, what was indisputable was that his marijuana metabolite levels were above the statutory prohibited level. And again, I have issues with the statute, but that wasn't challenged in the trial court. Otherwise, I would have devoted a lot more time to it and made an argument about it. But ultimately, there's a conflict with science in this case, and I think with the metabolite levels, and this is gonna come up, again, now that marijuana has been voted to be legalized, by Ohio voters, is that, when we take a metabolite level, which indicates that, okay, there's some past use, and I think even Lieutenant Schmoll admitted that, THC can remain in the user's system for some time after use. And so, the metabolite demonstrates that there's some past use, but it can linger in the system for a while, but yet that there's no impairment. And so, and here we have a statute in the book that says, oh, well, if you're just above this point, then we're going to say you can't drive, and therefore you must be impaired. And there's no science to back that up at all. That's an arbitrary number the legislature picked. And so, and the state presented no scientific evidence to demonstrate how the prohibited level of marijuana metabolite concentration in Mr. Balmert's system was a proximate direct cause or substantial factor in the collision with the state trooper in this case. So at the end of the day, these were just the prohibited levels of metabolite in the system and the collision were ultimately two separate events that have no connection to each other. And the state's trying to force that connection in order to, tag Mr. Balmert with a felony that had mandatory prison time. And I'm asking the court to reverse his conviction on aggravated vehicular assault on the basis of insufficient evidence because there is no evidence of proximate cause. Did Mr. Balmert cause the crash? Most likely, yes, and that's just simply because of his negligence, and that's something to be taken up in the civil courts. But for here, this case has no place in the criminal courts, and I ask the court to reverse his conviction on its insufficiency and or manifest weight.
Thank you.
Thank you.
And thank you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. When that decision is done, will be mailed out to you by the clerk